Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our two-weekly community conference call every other Thursday, in which we try to answer your questions as best as we can in the time and constraints of the information that we have. When you logged in to the conference, you would have heard certain disclaimers. Those apply to all our answers. Just real quickly, let me check if you guys can hear me. Just a second.
The conference is now in conversation mode.
Can you all hear me okay, guys?
Yes.
Okay.
Yes, speaking.
The conference is now in presentation mode.
Okay, so we have, today we have quite a large number of questions I consider to be frequently asked questions. So I'm not sure we'll have time for any new questions, but I'm going to try anyway. The first frequently asked question is, what are the consequences of unauthorized employment generally and for F1 visa students particularly? So generally speaking, unauthorized employment can be a big problem for those visas where your intention to remain or to come back to your home country is extremely important. What are those visas? For example, tourist visa, B2, B1, business visa, J visa, F visa, like F1 student visas. So there are some visas that have a particularly sensitive need for you to demonstrate the intention to come back to your home country. If you have worked without authorization, issuance of those visas becomes unlikely, if not highly unlikely. So if you have violated your student status, for example, it becomes a problem to get an extension. Now, of course, I'll come to the student status separately in a minute, but let me also address another aspect which is quite interesting and problematic. So there are certain things where the thing itself is not that big a problem, but if you try to hide it, it could become a huge problem. Unauthorized employment is sort of like that. If you reveal it, there is a cure for it in most cases, except those sensitive visas that I talked about, the F, the J, and the B types. But this kind of a problem would not affect like an H1B, L1, H4, L2. These are pretty solid visas. So even if you had unauthorized employment, you would not be stopped from getting an H1. I had a case where a physician had been out of status for 2 years because he accepted payments as an independent contractor rather than as an employee. Now that's a violation of the H1B rules. But we were able to send him back to Philippines, get his visa stamp and bring him right back, thereby curing the violation. So the violation itself may not be that big a deal unless you happen to be in a sensitive visa zone. But if you lie about it and you try to conceal it, it could be construed as misrepresentation, material misrepresentation, which can become a permanent bar from entering the United States. So the thing itself is not that bad, but lying about it could be quite problematic. Now let's address this issue in the context of student visas. So there are two kinds of problems. One is something called de minimis violation, where somebody violated, they didn't realize they had, for example, 2 employments going when they were supposed to have only 1, and that lasted 10, 15, 20 days. And as soon as it was discovered, they tried to take steps to cure it. How do you deal with those situations? Well, you can ask for a reinstatement, or you can travel outside, come back on the same visa, etc. Those are the couple of things that you can do right away. Now, where the violation is ongoing and long-term, their reinstatement or going outside and coming back will not be enough in all probability. What can you do? Well, you can try applying for a new student visa to come back in. I don't know if that would work. So actually, I take it back. As I say it, I realize that even that is not really an option. If you are unauthorizedly employed as a student for a long term, you cannot conceal it. That's really a big problem. But if you reveal it, chances are you will be asked to leave, okay? Or you could even be put in deportation. There's no such thing as a pardon. There are waivers for certain things. One particular waiver that everybody should be aware of is called a 212 D as in doctor number 3. 212 D3 waivers are actually available for almost all non-immigrant visas. That doesn't mean you're going to get it, but they are available. But still, if you have a problem that goes all the way to your green card because of misrepresentation, you won't be able to get a green card. So therefore, when you have an unauthorized employment issue, if you are not a student, any other status, be mindful you cannot lie about it. Nobody can lie about it anyway. And if you tell the truth, your sensitive visa, FJ, B1, B2, will probably not be granted. Okay? But lying is not an option. Concealing it is not an option. Okay? Now, for this gentleman who's written this message, he had a very sympathetic situation because of COVID. 4 members of a family of 5 were sick, and he had no choice. His bank didn't clear the payments, so he worked without authorization. I don't think there is any real possibility, this is my guess, of him being able to get reinstatement. Okay? So I think what he should do is, it's okay to talk with his DSO, see if they can figure something out, but be prepared to leave the United States and secure a job if it is possible. Keep applying for an H-1B. If you ever get through the lottery and you get an H-1B approval, you can then make sure that you reveal in your visa papers that there was a violation, but that's not a ground for denying your H-1B. Be truthful about it. So H-1B is definitely a possibility, but student status may be difficult to get back. Okay? *5. If you have a follow-up question on this, no new questions. If you have a follow-up question on this, please press *5. All right. Let's go on to the next frequently asked question. Oh, this is a huge problem for a lot of people. Denial of a downgrade I-140 on the basis of the employer's ability to pay and its impact on approved EBT and EB2 and pending I-485. So what is this scenario? You have an EB2 approval, like a lot of people did, including our own clients. You applied for a downgrade to EB3 because during a certain period of time, EB3 was moving faster than EB2. So you filed a second I-140. The second I-140 gets denied because of the employer's failure to demonstrate the ability to pay wages. Now, this is a known issue. When you develop software or you have developed software, you know what the known issues are, systems issues. This is a known issue. This is something that lawyers should look for before they file for the downgrade. Okay. Now, not every contingency can be planned for, but this is a known pain point. This could have been prevented. Remember, the law is the employer through whom you are going, unless they are an AC-21 Supplement J portability employer, any employer through whom you are going for green card must be able to show their ability to pay wages if called upon till the day you get your green card approval. So this issue could have been brought up at any stage. It's normal to do so, and it can have potentially disastrous consequences. Why? Because if you don't have the ability to pay wages on EB3, you don't have the ability to pay wages on EB2 either. Same employer, same employee, same situation. If the government wanted to be by the book about it, you could be getting a notice of intent to revoke your EB2 I-140 as well. Would that take away your priority date? I don't see how. Your priority date is yours. Okay? Unless the problem of ability to pay wages dated back to the original approval. So in other words, the original approval was made by mistake, then you could lose your priority date also. So this is a big problem. How do you address this? If I were you, I would sit with my lawyers and figure out if there's the possibility of starting another green card with this employer while this case is still going on, all these things are going on. Because if you are able to preserve your priority date and get another green card approval through PERM, and from now on the employer does have the ability to pay wages, then it makes more sense to file another green card through this employer or through any other employer. Okay? Star 5, if you have a follow-up question. Star 5. Press star 5. Okay. From area code 248. 248, where are you calling from?
I'm calling from Michigan.
All right, sir. Tell me, how can I help you?
So my question follow-up is that will the still EB2 485 will get approved because still there is no denial notice received, or there is no chances that it will get still approved?
There is always a possibility it might get approved, but like I said, if the government wants to play it by the book, they could be sending your employer a notice of intent to revoke the EB2 I-140. Okay?
Okay. And if the 485 get approved, then they cannot send again. Like
It's,
what I mean, like if 485 get approved, then they won't.
they can still remember, this is another issue of law that you need to bear in mind, that any I-485 approval can still be revoked within 5 years of approval. So if they wanted to, even after the 485 approval, they could send you a notice saying, oh, we've discovered something in your record that shows that your I-140 should not have been approved, and thereafter your 485 should not have been approved. So we are going to, here's a notice of intent to revoke the I-485 / green card approval, and a notice of intent to revoke the I-140 approval. Now, it's something they don't do very frequently, but it certainly is possible. That's the reason I think seriously considering another clean green card is a good idea, just in case if there's an issue in the future. All right? I have to move on if you don't have a question. Okay. Good luck. Next question. Now this is actually quite frequently asked. I have been answering this question, these questions and related questions for a long time. For the first time, somebody has asked them all in one posting. That really helps. So the question is, now that I've got my H-1B approval, do I need to go for stamping? Is it possible that I can get a visa while I'm still in the United States? Can an H-1B visa be rejected? Now, important to understand the concept of a visa. A visa is a permission for you to enter the United States. So the only time it becomes relevant is when you travel outside the US, because then you need to re-enter. So a visa is a permission to re-enter the United States after you have been abroad. But while you are in the United States, you only need your I-94 and your petition approval, which is what you get when you get a change of status within the United States. So keeping that principle in mind, is it required? The answer is no. It is only required if you travel outside. As long as you received your change of status with an I-94 attached, which is actually the bottom fifth part of the approval notice. It says arrival departure record and cut here. There's a dotted line. That's what it would show. In such cases, you are fully authorized to continue to stay in the United States and continue to work as long as that approval is valid. Okay. If, on the other hand, you need to travel out, then before you can come back in, you'll have to get your visa stamp. Can you do it while staying in the United States? Now, this is an interesting question. Some people have reported that they actually send their passport through some family member or friend to apply for a visa at a consulate, and because many times these interviews are waived, so they don't really need to be there. Now, I'm not sure how far that is legal. I have suggested that to other people. Please write to the consulate, ask them what they say. I think it's contrary to my instinct to say this is okay to get remote visa stamping. I think you should be physically in that country. But I do not know the answer to this question definitively, nor do I know if it has ever been answered by anyone. So it's a good idea to check with the consulate, and they do respond to emails. And please update us. You can send me an email. I'll share it with everyone. My email is help@immigration.com. I am not sure that it can be done remotely. Okay. Now, third question is, can an H-1B visa be rejected? Absolutely. Happens all the time. What are the typical grounds for rejection? One, they are not able to verify your employment with the end client if you are working at an end client instead of an employer directly. Second, they find some problem with the H-1B petition, such as an inappropriate or unapprovable job description, job requirements, etc. Third, any problem with the company's background. Fourth, any problem with your own background. So there are many, many reasons, and they can certainly delay you a lot. They put the paperwork in administrative processing, 221G. You could be stuck for months and months and months. So when you go for visa stamping, it's a smart idea to prepare for these eventualities and see if you can continue working from outside the United States if the employer permits you to. While you are waiting for the H-1B to be approved, you can be working from your home country. Now, this is just the worst case scenario. It's definitely not the usual experience for everyone, but just be mindful of that. Let me make sure I got all the questions. So is the H-1B stamping required for H-1B transfers? No. Is it required for H-1B renewals? No. Is it required for green card process? No. As long as you are maintaining status, there is no need for any of this. I think I've covered all the questions. Press *5 if anyone has any follow-up questions on this. Press *5. Okay, we have area code 513. Area code 513, where are you calling from?
Hi, I'm calling from Cincinnati.
Cincinnati, okay. Go ahead.
So I just had a question. So I was on F1 visa until the latest lottery happened, and my H1 got picked, and my petition is approved. It says on the government website status, but I've not received my copy yet.
Okay.
The I-797.
Okay.
So would I be eligible to change my job and initiate a H1B transfer, because I have not traveled to my home country and I don't have a stamping yet on my passport for H1?
I would advise you to wait till October 1st, assuming that that's when your H-1B kicks in, because there are whispers from the government that if an H-1B is revoked or withdrawn before October 1st, you are back in the lottery. You are not quota exempt. So I would wait until October 1st or later. Okay? Good luck.
All right. Thank you very much.
You're welcome. Next frequently asked question: how can we keep the immigration benefits of an approved I-140 which is priority date and the right to extend H-1B beyond 6 years through any employer. So this is the way the law was written, and this law became effective on January 17th, 2017. The moment your I-140 is approved, your priority date is yours to keep. It can only be revoked if there is fraud, misrepresentation, or some gross error in your paperwork for the I-140 approval. So the moment the I-140 is approved, the priority date is your property. You can leave this employer, go somewhere else. You'll have to start the green card all over again, but you keep that date. Number 2. If the I-140 stays approved for 180 days without withdrawal or revocation, you also have the right to keep extending your H-1B beyond 6 years with any employer until your priority date becomes current when you're supposed to have filed the I-485. And your wife also has the right to keep extending her H-4EAD based upon your H-1B extensions. Okay, so the I-140 approval, upon approval, immediately gives you the priority date to keep forever and ever. And by the way, that priority date can be transferred across visa categories and job categories. So let's say you have a degree in computer science and another degree before that in chemical engineering. You could go from getting a green card under computer science to getting a green card under chemical engineering, and you could use the same priority date. Also, the priority date approval could be EB2. It can be used in EB3, EB1, any of those categories. So across job categories, job descriptions, it can be used. Okay, this is not like AC-21 portability where jobs have to be same or similar. For priority date transfer, jobs do not have to be same or similar. Once the I-140 is approved and stays approved for 180 days, you have the right to extend your H-1B through any employer beyond 6 years. This is true even if you left the employer 10 days after filing the I-140. So you don't have to maintain the job for 180 days. Your I-140 must remain unrevoked for 180 days. Okay, I hope that answers your questions. Let me just double check. Do you have to do anything? No, this is automatic. One other issue here is, what if there's a change in location after the I-140 is approved? I don't really worry about that. Why? Because if the I-140 was filed in good faith and on the date it was filed, the information was correct, after approval, if things change, I'm not worried about that. That 180-day rule still applies. From the date the I-140 was approved, we start a countdown of 180 days. *5. If you have a follow-up question, press *5. Okay. I think we are done with frequently asked questions. I was surprised actually. These are, here's another one. Very important questions, I think. Very smart questions too. Can we file more than one AC-21 portability supplement J if we continue changing employers? Yes. There is no limit on how many times you can change employers on AC-21 portability. So let's say my I-140 is approved, 485 has been pending for 180 days, and my green card was filed by Microsoft. I decided to change jobs to IBM. As long as the jobs are same or similar, including a promotion, I can file a supplement J. I worked there for 6-7 months. Then I got a much better offer from a fintech company on Wall Street. I moved over to the Wall Street company. Again, I can file a supplement J. So I can keep moving from job to job if they are same or similar. And you do not need to work for 180 days. There's no such thing. 180 days, once qualified, then stays qualified. You could join an employer, work for 10 days, and decide to leave, file another supplement J, work for 2 months, then leave again, file another supplement J, work for 3 months. So there's no requirement that you must work for an employer for 180 days. Okay. *5. If you have a follow-up question on this, press *5. Oh, there's another one. And this one also says, please do weekly telephone calls. I would like your suggestions. It is not possible for me to schedule multiple calls weekly. There's a whole lot of things going on. We already do calls every Thursday. One I do through our firm and one I do with UD or someone else. And there might be even more than that depending upon a student association reaching out to me and they want me to work with their members. So those kind of things keep happening. If you want to send me your suggestions, here is what I can do. Many times, let's say one of my conference calls gets deleted. I'm sorry, deleted, rescheduled, okay? And I have 15 minutes of free time or half an hour of free time. I can do a quick conference call and invite people in to answer their questions. Now, I can think of one way, which is through Twitter. I think Twitter has a way in which we can hold conference calls and anybody who's available can come join. So I can't do it on LinkedIn because I like to keep people's identities confidential. I think that might be the same problem on Twitter also. But if there is any way you can think of where we can do quick phone calls and invite people whenever I have a few minutes time and I can try to answer as many questions as I can, I'm open to suggestions. So send me your suggestions if you have any to help@immigration.com. I cannot schedule more than pre-scheduled calls that we do almost every week anyway. That would be too much, but I can certainly find time whenever I have the opportunity and try to connect with you all, okay? Now the question here is this: how can we expedite the filing of a PERM application? Now remember, there is no way to premium or to expedite a filed PERM, but how do we get to the finish line to filing the PERM quickly? The only thing I can recommend is, the biggest pain point in PERM applications is the prevailing wage. It takes 7 months to come through. What I would do is, in about the 5th month of pendency, I would do the job posting notice, because the job posting notice has to stay up for 30 days. And this is with the local, sorry, what am I saying? Not the job posting, the job order notice or the job order which is filed with the local employment commission in the state, okay? That could save you a few weeks' time. So that's the only thing you can do. That's what we do routinely in our office because it doesn't cost anything. And if we need to do it again, if the category is something other than what we had anticipated, and Department of Labor says, no, this is not a systems analyst, this is a software developer, we can just redo it. We haven't lost anything. So keep that in mind. That's the only thing you can do. *5 if you have a follow-up question. So do the job order. That's the only thing you can do. And you have to time it towards the end period, because if you start the recruitment too early, and that would not count. You'll have to do it again. Okay, there is no question here. Oh, here's another one. Boy, there were a lot of frequently asked questions today. So this is an interesting question too. There's a STEM OPT student. Can he have more than one job? Yes. STEM OPT people can also have more than one concurrent job, but they have to work with their DSO to make sure the proper paperwork is filed. Okay. Now, can I also have multiple green cards going with multiple companies? And the answer is yes. As long as there is a good faith intention to join any one of these employers who can get me my green card, I don't see any problem with having multiple green cards through multiple companies. And does the size of the company impact the green card? It does not impact the speed of the green card. What is most important is the company's financial solvency. So if the company has a good ability to pay, I don't care what the size of the company is. We have done green cards for companies with 0 employees, where our individual client was the first employee hired by the company, and that was accepted. The guy has his green card now. So it's not really the size of the company, but the solvency of the company. I think I've covered everything. Question number 3. If H-1B change of status is approved through one employer, can I still continue other jobs and green card process? Yes, you can. Remember, if you have multiple H-1B approvals, one approval doesn't overrule another approval. Of course, the employer is supposed to withdraw the H-1B if you don't join them, but you can have even multiple H-1B approvals living together in the same space. Can I work remotely? Remote work is possible for both OPT, STEM, H-1B, and green card jobs. All of them have their issues. So for example, STEM OPT requirements are more restrictive. Government, USCIS and ICE had given exceptions to people during the COVID times to work remotely as long as they could be supervised, or there was a branch of the company where they were being supervised. So for first year OPT, it's not an issue, but second year OPT, STEM OPT extension, rules can change. Under the old rules, you could not work remotely, you had to be supervised. But if you could be supervised, then even remote work then was not a problem. For H-1B, absolutely no issue, nor is it for a green card. *5, if you have a follow-up question on this, press *5. Okay, this one is from area code 650. 650, where are you calling from?
I'm from San Jose, California.
Yes, ma'am. How can I help
Hi,
you?
Rajiv, and thank you for sharing information. So I'm asking a question for one of my clients, and he went back to China, and he had the master's degree of U of Pennsylvania. So now he wants to come to the States and work in the States. What would you suggest?
Well, same thing as other people do. They would have to either get an H-1B, L-1, O-1, any of the work visas. Or they could come back and go into a degree program that allows for curricular practical training, so they could go to school and get CPT work authorization.
Yeah.
Okay.
But he wasted his OPT already. He already graduated.
No,
master's
ma'am.
degree.
I'm not talking about OPT. I'm talking about CPT, curricular practical training.
Oh.
Okay.
Okay, I see.
All right.
Oh, okay. I see.
Good luck.
So another question.
Yeah.
Okay.
These questions have to be related to what I'm discussing. Okay. I can't take any random questions.
Okay.
So unless you have a related question, you have to wait till the end. If I have time, I'll call on you.
Okay. Yeah.
All right.
Yeah. Thank you.
Okay. So the way we work is, when I answer a question, if you have a related question, I'll be happy to answer it. Otherwise, we'll take new question at the end of our conversation, if I have time at that time. So let's go back to answering other questions, which are not frequently asked. Let's see. I think a lot of the questions have been answered. This was frequently asked. Done. Okay, this one. Applying for green card during merger or acquisition of a company, an update on the H-1B dual wage hike rule. So the wage hike rule was put in the freezer. For now, that's not an issue. And I can't really answer these questions because it's going to take me a long time to do that. But I can give you the general law, and hopefully that will help you. So normally, if there is a merger or acquisition, there is one situation under which it has no impact on anybody's immigration processing. And that is if the company that comes in and takes over the business has stepped in as successor in interest, which means they have undertaken or taken over either the stock of the company, in which case actually even a successorship is not needed, or they have acquired substantially all assets or a discrete business unit of the company, and they are continuing the same business, same location, substantially same jobs, and they are taking over the immigration processing. So in those cases, H-1B, green cards, everything remains good. We might have to file I-140 amendments, but you don't have to start the green card from the beginning. So that works out. Let me just take a quick look. If I-140 amendment for merger gets denied, you should keep your priority date, and you will have to file PERM and labor again. And if the I-140 previously approved I-140 stayed approved for 180 days, you are then allowed to keep extending your H-1B also. Okay, so this is the best I can do. I already covered the 180-day rule. You don't have to be employed with that company to take advantage of the 180-day rule. By the way, let me just lock people are still logging in. I'm just going to lock the conference.
The conference is now locked.
That way I can answer the questions of people who are already logged in. All right, so I'll make sure that I answer all your questions before we hang up. I just don't want more people to come in, then I don't have enough time. Any follow-up questions on what I just discussed about the merger acquisition? Press *5. Any follow-up questions? Okay, next question. National Benefits Center processing, address and mailing. If my address changes after the petition was received at the NBC, does the field office processing my application change? Is the field office based on mailing address or physical address in the petition? Now, when you initially file the case, where the case goes depends upon what you are filing and where you are filing it from. But if there is a movement either to a processing center or to another center for their work redistribution, normally the change of address should not affect that. Okay. How do I determine the field office and processing time applicable for my petitions? So until the benefits center, NBC should have its own processing time. Normally they send, now again, this is a unique situation because certain things are being done right now which were not done outside the COVID times. You may want to call the USCIS customer service and ask these questions, but normally when the case goes to a benefits center, it goes for distribution. Either it goes to process at a field office or a service center, depends upon how they are distributing the work. Okay, so what I would do if I were you is I would check with them what they are doing and then check on the processing times for the center where it's being redistributed or being routed. That's the best I can tell you. *5 if you have a follow-up question. Press *5. Okay. Checking the ETA 9089 status. Case is still pending. 99% of October cases, 75% of November cases have been issued a decision. Is there a wait period before I can open an inquiry with the Department of Labor? I do not believe so. You can check with them. But normally I don't think you as an employee can. Your employer or your lawyer would have to. Okay. There's not much you can do. This is going to take what time it takes. *5 if you have a follow-up question on this. Press *5. Area code 661. 661, where are you calling from?
Hi, Rajiv.
Yes, sir. Hello.
So the question of the ETA 9089 is, so if let's say another 2 months passes and if we don't hear on the status, what can we do at that time? from employer or attorney?
You can send a inquiry about the status of the case, not you, but employer or lawyer. These things don't help much. It's going to take the time it takes. Okay.
Okay. If I may ask a follow-on question, have we seen cases like that for PERM that takes much longer than the other use of standard?
All the time. All the time. Because not every case is the same. Okay.
Okay.
And there is no government has said this in open court many times, that we do not follow strictly first in, first out. So nobody can say, well, my case should have been attended to earlier. You don't have a right to first in, first out. Okay. Make sense?
Yes. Thank you so much.
Good luck. Okay. So the next one is, this is also very interesting. Can I get an H-1B stamped on a Swedish passport while I have an Indian passport? I just answered this question yesterday in a consultation. First of all, if I remember correctly, India requires you to surrender your passport. So you don't have an Indian passport. You have to get the H-1B stamped on your Swedish passport. But here is the fun part. It does not matter if your H-1B was approved while you were a citizen of India. When you go for the Swedish passport stamping, that's perfectly normal and it's perfectly acceptable. So don't worry so much about it. Okay? You should be able to get it stamped, no problem at all. *5 if you have a follow-up question on this. Press *5. Okay. You are calling from Sweden. Okay. Hi, how are you, sir?
I'm doing good. Thank you for answering the question. So basically, I got this approved in 2020. And I was thinking, because it was approved on the Indian passport, I was thinking if I get it done on my Indian passport and I renounce it, can I travel to the US on
No.
with an Indian passport in tow?
No. If they don't give you the passport back, I don't think they do. I'm not sure what the procedure is. Frankly, I never surrendered my passport. I forgot completely, and I don't even know where it is.
They put hole in the passport. Yeah, they punch a hole in the passport.
Yeah, if they puncture holes, I think you should be able to use that visa. But if I were you, because what you would then do is you would travel with the Swedish passport and the Indian passport together. But if I were you, I would just get my Swedish passport stamped. That's the easiest thing to do.
Oh, can I get it done before coming to the US?
Of course.
Just transfer the visa?
Absolutely. It's not a transfer.
Okay. Then fine.
You are applying for a new visa,
Okay.
saying that because my citizenship has changed and I have surrendered my Indian passport, could you please stamp my Swedish passport? And if they say, no, you don't need it, you're fine, good. You can then keep both passports when you travel. But that's just a hassle. In my view, it's easier to just get this visa stamped again on Swedish passport. Okay?
Okay, then I don't need to go into the lottery and everything again.
Oh, no. Lottery is out. I don't think you should have a problem with that at all.
Yeah.
Okay?
Okay, perfect. One more question regarding this itself. So I'm in the process of getting it stamped. So I can directly go and get it stamped in the Swedish passport and enter in matter then.
You can directly get it stamped on the Swedish passport. Yes.
Yeah. Okay. It doesn't matter. Okay.
Yeah. Drop me an email to help@immigration.com. Help@immigration.com. Just to let me know what the outcome was. I don't think it'll be any problem. Okay?
Perfect. I'll do that. Thank you.
Good luck. Yeah, we do that with people who've gotten citizenship of Canada all the time. So no issue at all.
Okay. Because I was just confused and worried because if I apply for a Swedish passport, I can't go back to my Indian and the visa would.
No. You shouldn't have to. We had a case recently. So Canadians don't need a visa, but they were able to travel with Canadian passport and approval on the Indian notice. That's not a problem at all. I don't see any issue here.
Okay.
Okay. Good luck.
Okay. Okay.
Bye-bye.
That makes sense.
The next question is from area code 803. 803, where are you calling from?
I'm calling from Columbia, South Carolina, sir.
Okay, do you have a follow-up question?
The one you just...
Hang on, do you have a follow-up
Yes,
question?
follow-up question related to the same. Yes, sir.
Go ahead.
This is the same question you just answered. I'm also in a similar scenario. I couldn't, log the question. So since this question is posted by someone, I just thought of, joining and asking the question.
Okay.
So since in this case, H1 is already, approved with Indian passport.
No,
while
but
on
that shouldn't matter. That shouldn't matter, because the H1B
so
doesn't.
there's no change in papers, H1 papers needed.
I don't think it should matter at all.
Okay.
Okay.
Just want to check on that one only, sir.
Yeah, I don't think it will matter at all.
Exactly same thing.
I encourage you to just drop me an email if you have any problem. I would like to share it with the community. I don't think it's going to be an issue at all. Okay? Good
Thank
luck.
you, sir. Because that's what, we are just waiting for the citizenship. And, whether we should wait for the citizenship or, should I go and transfer, stamp on the, Indian passport. So, since you mentioned, I think just wait for the citizenship and get it stamped. I think
Are you getting citizenship for Canada? Which country are you getting it for?
Germany, sir.
Okay. Yeah, so I would wait until the citizenship comes. Canadians, I might advise a little differently depending upon where they are. But Germany, definitely get your passport stamped once a passport comes in. The German passport. Okay?
Okay.
Good luck.
I was just thinking if I go and stamp an Indian passport, I'll save some time.
Well, you can also email the consulate. You can email the consulate. Let them know what your situation is. But I personally feel, because they hole punch it, I don't know if it affects the machine readability of the visa. I think it might be easier to just wait till the German passport comes. You can send an email to the consulate also, doesn't hurt. The US consulate in Germany.
Perfect, sir. Thank you very much.
Good luck. Okay, then H4 extension without EAD. My wife is on H4 dependent, expires in August. She does not have an EAD. She got admission in dental school. We filed a change of status. TSO told us to file H4 extension on safe side, to be on the safe side. Yeah, I think the last action rule becomes a problem, because you filed for F1 change of status, then you filed for H4 extension. If the F1 gets approved first and H4 later, she'll be back on H4. But I think the easiest thing to do would be to file for the H4 extension and be prepared to withdraw it as soon as the F1 is approved. If the F1 doesn't get approved, then obviously you have no problem. H4 status extension gets approved or is still pending. F1 gets approved, you revoke or withdraw the H4. If the H4 is approved before the F1, then when the F1 gets approved, the last action is F1. Okay, so that's the way I see it. *5 if you have a follow-up question. So the last action rule would apply, but it shouldn't hurt you because you can plan for it. Area code 216, where are you calling from?
From Ohio.
Yes, go ahead,
Hi,
please.
sir. But my question is that if my F1 gets first approved, then and later my H4 approved, but still on my valid state date for H4 extension will start from August, and F1 will be later on when the day it will approve. So
it's difficult. I think you are back on H4. That's what I think. Okay.
Okay.
Because
like a status date valid from that.
I'm making. You can call the USCIS customer service, check with them. I have a feeling they would say that you're back on F1. I hope I'm wrong, I could be. In cases like this, I always call the USCIS customer service. They usually put me in touch with the adjudications officer, tier 2, and I can usually trust their advice on these issues. So that's what I would recommend. Contact USCIS, ask the customer service the question. They will probably escalate you to level 2, which is the actual USCIS officer. Write down what the USCIS officer says, their name or badge number, and the date you talked with them. You can usually trust that advice, usually. Okay?
Thank you.
You're welcome.
Thank you
Good
so
luck.
much.
Okay, so we answered this question, this one. Will an H-1B petition be approved if the I-140 date becomes current before the petition is filed? So here is the problem. They will not approve an H-1B if the priority date is current and you have not yet filed a 485. But you know what? I would argue that under the regulations, I have 1 year to file the 485. That 1 year is not up. My priority date just became current. You give me my H-1B extension and I think I'll get it. Either I'll get it from the USCIS or I'll take them to court. That's the way the regulations are written. Okay? So I think you should be entitled to your extension. Star 5, if you have a follow-up question. Star 5. Okay. We've answered this question. So recapture of days spent outside the USA while on H-1B and I-140 porting and AOS. Let's see. I'm on H-1B I-140, came to India to get my H-1 stamped, got stuck. 221G RFE. I got stuck again due to the end client issue. COVID made things worse. I have an approved I-140 with my old firm. I'm not on US payroll. If a new firm had to take over my H-1B, can I recapture the unused time? You see, you have the right to keep extending your H-1B because of your I-140 approval. Okay? If your I-140 was never revoked, you can extend your H-1B with any company as long as your priority dates are not current. Can I port my old I-140 priority date? Yes, you can. What is the porting time frame? Listen, you have to start a green card all over again. Don't make that mistake. You just get the priority date. You don't get to transfer your green card. You have to start the green card again. And can a new employer file for AOS? No, because they have not filed your green card. They cannot file just an adjustment of status. They have to start your green card all over again. But you should carry the old priority date. Star 5, if you have a follow-up question on this, press star 5. Okay, anyone has any question, press star 5. All right, I'm going to proceed in the order in which you logged into the conference. So far I have 4 questions. All right, so I'll start in the order that you logged in. So this one is area code 661. I just unmuted you. Go ahead, please. Area code 661, California.
Ji, Rajiv. So I want to ask, and this is follow on my PERM taking way too long. I do have my PERM and I-140 approved from previous employer, and I have an option to start the 485 process with them with ability to join in future. Should I be able to run both of these GCs in parallel and file 485 with both of?
Yes. But review our frequently asked questions on immigration.com. In the last community conference and many times before that, I have discussed this issue several times in detail when you try to apply for a 485 through an old employer. So can you do it? Yes. Should you do it? Just listen to those frequently asked questions. You can always set up a consultation with us if you need to, but I think all these questions are comprehensively addressed. Okay?
Thank you, Rajiv.
You're welcome. Okay. Now let's go to, this is New Jersey. New Jersey area code 551. Go ahead, I have unmuted you.
Hello, Rajivji. I'm currently on my post-completion OPT, and it's going to expire on 4th of July.
Okay.
Now, the situation is I already got picked up for H-1B in this year's lottery.
Great.
My company filed for the H-1B petition.
Mm-hmm.
In the meantime, while I was filing for my STEM extension, because of the macroeconomic situation, company had to lay off certain amount of people, and I was in the pool.
Mm-hmm.
Now, in this situation, company helped me to, so I asked them to keep me as an employee until I have my STEM extension, so that I have some status to stay in the US
Sure.
and then find a new employer
Sure.
in the meantime.
Sure.
So they are keeping me, so STEM extension is solved, but then about H-1B, I've discussed with some friends and then also people from my company who handles all this immigration situation. And then currently what we have decided is to process my H-1B as a premium processing so that I can get H-1B approval quickly.
Mm-hmm.
And also file the petition, convert the petition process as consulate petition. Will that work out? Because I see here is, so what steps should I take?
Well,
Does this plan
the
work out?
problem is that there are two things that are fighting against each other. One is, how do you maintain your status on H-1B until October 1st? One day after that, you can transfer your status to another employer. And the second is, every employer who files an H-1B should file it in good faith, where they have a genuine job. And two, they have to revoke the H-1B if they are not hiring you. That's required by law. Otherwise, they are required to pay your salary. If I were advising the employer, I would tell them, do not file this H-1B because you have no intention of hiring him. Okay? It's illegal for you, in my view, to file this H-1B. If I were advising you, I would tell you, stick to your OPT, get your STEM OPT, and start looking for a job on STEM OPT. Forget about the H-1B. Okay?
Okay. Just one more follow-up on this. Here in the situation is, so I will join a new company with my STEM. And before I leave company, because of the premium processing, I will get my approval. But then, can I transfer that H-1B after 1st October?
Absolutely.
With the new employer?
Yes, you can.
Okay, so I will have a H-1B approval in my hand, but then I will join a new employer with STEM OPT.
Right.
And then after 1st October, I will ask my new employer to transfer.
Absolutely. One thing I want to point out to you, if you get an H-1B processed with consular processing option and you don't get a visa stamp, sometimes government says you haven't really gotten out of the lottery yet. You have to receive either a change of status or visa stamping.
Okay.
I think they are wrong. I think their interpretation is wrong. And I have actually done many cases where they approved my H-1B, even though I never got the visa stamped or change of status. But I'm putting it out there that this is their interpretation. Officially, this is what they say. But when we push it, we are able to get our H-1B. At least we have been able to. But this may or may not last. So be careful. Where possible, get a change of status. Okay?
Okay.
Even if the change of status, if it can't kick in,
and by the way,
it cannot kick in earlier than October 1st. So get the change of status. Don't do consular processing. I think that would be better for you.
Okay.
Good luck.
And can you?
I'm going to give you 10 more seconds. I have to move on. Okay, give me Make it really short. Ask me your question.
Wanted to know your email.
help@immigration.com.
Okay, thank you. Thank you so much.
All right, folks, let's go on. I have a meeting scheduled in about 5 minutes, but I'll finish these questions. Let's see. This is Ohio. Ohio 937. Go ahead, please.
Hey Rajiv, quick question. I filed my 140 and 485 concurrently. 140 approved after 2 months.
Okay.
So in this case, when does the 180-day clock start?
Only 4 months left. 485 clock begins the same time when the 485 is filed, and it starts ticking when the I-140 is approved. But it starts ticking from the date the I-485 was filed. So you have only 4 months more to go. Okay?
Okay, so basically whatever date is on my 485 receipt date, that's where it is.
And it's 180 days, not 6 months. 6 months is more than 180 days.
Correct.
Okay?
180 days.
Good luck.
Okay. Thank you.
You're welcome. Okay, the last call for the day is from Utah. Salt Lake City. Go ahead, please.
Hi, Rajiv. So I had a question on same or similar definition. So if we submit 485J with same or similar, and does USCI issue an RFT if they don't agree, or they outright reject?
Yes.
And if they reject, does that affect?
No, wait.
Okay.
They issue an RFE, and if they reject, you can always go to another employer.
Okay.
I don't see why not.
Okay, so that's not automatic denial of.
No, sir.
We can always go to another employer and file another. Okay.
I've never had to do that because 99% of the times we can tell whether the job is same or similar. Remember, I've done cases where people went from being a software developer to a CTO, and that was still same or similar job. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Oh, this was perfect timing. I do actually have 10 minutes. Okay, very good. Good to see all of you. Thank you for being here. I'll see you again in 2 weeks. And remember, if you have any suggestions on what medium we can use to do quick telephone calls where I have 5, 10 minutes, 15 minutes, I can invite people who have questions. Let me know your suggestions at help@immigration.com. Thank you all. Bye-bye.